once again in session.
We're once again in the record in the case of People versus Simpson. The defendant is present with counsel. The people are represented. Dr. Golden's on the witness stand. I remind you, sir, that you remain under oath. Mr. Shapiro.
Thank you very much. Good afternoon, Doctor.
Good afternoon.
Doctor, I was presented this morning with a 3/4 page form that indicates curriculum vitae, and it's dated May 5th of '94. Is this your current resume?
Yes,
And is it up to date?
I believe so.
I notice in here that it indicates a space for current academic appointments, and it's blank. During your tenure, have you had any academic appointments?
No,
And it indicates in here current medical staff appointments, and it's blank. During your tenure, have you had any medical staff appointments?
no.
Then the next thing that's listed is the concise summary of your role in the forensic pathology program, and it lists 3 things: that you perform autopsies, courtroom testimony, and lecture. Does that cover the gamut of the summary of your role as a forensic pathologist?
Trying to think if there's anything I've omitted. Basically so, yes, unless there's some things I haven't recollected. It's basically I'm a deputy medical examiner and forensic pathologist. I don't have any medical school faculty appointments.
There was some talk before about you being a physician. Have you ever practiced medicine?
Yes.
Now, it indicates you're a lecturer. What type of lectures do you give, and to whom?
That would be intramural lectures at the Department of Coroner.
I'm sorry, I didn't hear you.
That would be intramural or interdepartmental lectures at the Department of Coroner.
So you talk to your colleagues?
That would be, yes, yes.
And courtroom testimony, you told us, I believe, that you've testified approximately 700 times?
Approximately, yes.
And how many of those 700 times have you been called as a witness for the prosecution?
Many times, hundreds of times.
How many of those times have you been called as a witness for the defense?
I don't have the tally. In civil cases, I could be called by either the plaintiff or the defendant, so I wouldn't know. I have testified in civil cases, but in those instances, I'm not sure whether it's been the plaintiff or the defendant. In most of the criminal cases, the prosecution calls me as a witness, but not invariably, because I won't say frequently, but occasionally the defense counsel wants us called as a witness rather than accepting a stipulation.
Have you testified in any other state as an expert witness other than California?
Not as a friend, no, I have not.
And have you testified in any other city, or any other county other than Los Angeles County as a forensic pathologist, as an expert?
Well, as the medical examiner, some of my cases have been in other counties. I'm sure about San Bernardino County. I have been in Santa Barbara County. I have been called as a witness in Santa Barbara County, but it pertains to a Department of Coroner case. But it was a civil case, and either either the plaintiff or the defendant called me, but the reason I went there was not as a consultant because the decedent came under our jurisdiction. But I did testify at a civil case in Santa Barbara County, criminal case in San Bernardino County, but I would be available in criminal cases in any county in California.
Now, also on your curriculum vitae, you have a title list, representative publications from the last 5 years. And you have included yourself as a co-author in 1989 of a 4-page magazine article dealing with pneumonia in infants. Is that the extent of your publications?
Yes.
Have you reviewed the general text in the field for determining time of death?
Excuse me, did you say text or texts?
Text.
I still don't... Singular.
Books.
Yes.
And what books have you relied upon in forming opinions as to the cause or as to the time of death?
I have read forensic pathology textbooks, and these would be the standard texts, Gradwell's Forensic Medicine, Spitz and Fisher's Medical Legal Investigation of Death, latest edition. Adelson, Pathology of Homicide. DeMayo's text on forensic pathology, and Knight, K-N-I-G-H-T, and Knight's textbook on forensic pathology. And these are all standard references available to me at the Department of Coroner.
And in reviewing those sources, would you agree that the following factors are to be considered in determining time of death? First, rigor mortis.
Yes.
Second, libidity.
Yes.
Third, temperature change.
Yes.
Fourth, digestion in the stomach.
Yes.
And fifth, eye fluids.
Yes.
Anything else you'd like to add to that list?
Eyewitness.
Eyewitness. Okay. That'll be 6. Anything else?
No, I think that covers it.
And would you say that one of the important roles of your job as a deputy medical examiner is to ascertain the time of death in a homicide?
I would say to help determine a range of the time of death, yes.
And there are other people who you work with in forming those conclusions that are part of the coroner's office, is that correct?
Yes, that is.
And that would be a medical investigator?
Yes.
And a deputy coroner?
Yes.
Would there be other members of the team that you would rely on for that type of information?
No, the deputy coroner, the coroner investigator would be our eyes and ears in this matter.
And those people have also filed reports that you've included as part of what you've called the autopsy report or autopsy protocol, is that correct?
Yes, that's correct.
And you reviewed their findings prior to testifying today?
Yes.
In reviewing their findings, regarding Nicole Simpson, were you informed that she was found and pronounced dead by a member of the Los Angeles Fire Department Engine 19 squad?
Okay. I guess I can't find the relevant page in my protocol here. Yes, okay.
Take your time.
Yes, LAFD engine 19, pronounced by LAFD engine 19.
And what was the time that the decedent, Miss Brown, was pronounced dead?
Objection, Your Honor, calls for hearsay.
Sustained.
Your Honor, may I be heard on that?
All right.
Did you, may I, first, I believe these are official records and part of the autopsy protocol, which he's indicated, and that if he has relied on these records in forming his opinion, he can testify to it. Second, hearsay is admissible at these proceedings.
Yes, Mr.
If I
Hodgman.
may be heard, Your Honor.
Yes.
First of all, the people have elicited no opinion with regard to time of death, nor do we intend to. We have an independent factual basis for that. So there is no foundational aspect to this. Second of all, it is complete hearsay. There is information in a report, and counsel has the burden of establishing this as an official record. And it is hearsay upon hearsay, and hence still inadmissible.
Your Honor, if the people are going to contend that a case report from the county coroner as part of the autopsy report is not the official record, we'll take the time to establish that foundation.
Well, at this point, it's hearsay, and the witness not being a peace officer, there is no exception to his being able to relate hearsay. So at this point, the objection is sustained.
In forming any conclusions or opinions in your case, did you at all consider the time the decedent, Nicole Simpson Brown, was pronounced dead?
Objection, Your Honor. No foundation in evidence thus far, and making a bit ambiguous as to which conclusions and opinions that counsel is interested in.
Sustained.
You testified that it was part of your job to determine the time of death.
Objection, Your Honor. This states the evidence.
Is that part of your job, to determine the time of death?
Yes, only I would use the term estimate or range of the time of death.
All right, the objection's overruled.
And what factors did you use to estimate the time of death or range of time of death for the decedent, Ms. Brown?
Objection. This states the evidence. This witness has not made an estimate as to time of death.
Well, we haven't heard of an estimate as to time of death. So it assumes fact that's not in evidence yet.
Have you made an estimate in your official reports, or has anyone from the coroner's office made an estimate as to the time of death of the decedent, Mrs. Brown?
Objection, cut down.
Sustained as to someone other than this witness.
I'm sorry?
It would be sustained as to whether someone other than this particular witness made such an estimate.
Did you make an estimate as to the time of death?
There's no official estimate in my report. There's
Okay.
nothing written down.
I'm asking you, have you made an estimate? Did anybody ask you, as the head person investigating this homicide, to make an estimate as to the time of death? Yes or no?
Objection, that misstates the evidence. He's not the head person investigating this homicide.
Well, I think we know what he means. Overruled. Has that been asked of you?
Yes?
Who asked that of you?
Well, my boss, Dr. Lakshmanan.
Did you give him an answer?
Yes?
What was your answer?
My answer was...
Are you referring to something?
No.
It looks like you're reading something to me. Maybe it'd be simpler that if you need to refer to something, if you could put that aside, and then if you need to refer to it, just ask us. Would that work for you?
Surely.
Okay. Would you kindly put that aside? Now, would you tell us what you told your boss, Dr. Lakshmanan, regarding your estimate of the time of death of Nicole Brown?
My estimate was based on the state of the gastric contents and the character of her gastric contents, it was somewhere 3 to 4 hours after her last meal.
That was the only factor you relied upon out of the 5 or 6 factors that you listed?
No, I haven't finished yet.
Oh, I'm sorry, I didn't mean to interrupt you.
Then using that evidence, along with the body temperature determinations, which were taken approximately 11 hours after the body was discovered, I used a formula, graphs, to reach a conclusion that the range of the time of death was somewhere between 10 and 15 hours prior to the time the investigator took the liver temperature determination.
So you used 2 of the 5 criteria. Is that correct?
And
Oh, you haven't finished yet.
And then considering the rigor mortis determination, which at the time the investigator performed her determination, the body was in full rigor. Now I may pick up and look at page 1 of the coroner's protocol. The rigor mortis was fixed and was fully fixed. So that also placed the time of death somewhere beyond 9 to 12 hours. In other words, it was fully fixed at the time, which was probably known at the time of the pronouncement of death. And livor mortis was also fixed, and rigor mortis was fully established. So four of the measurements or examinations were performed.
Let's go through each one of those, if we might. Regarding rigor mortis, what time does the case report that you just referred to indicate that an observation for rigor mortis was first done by somebody from your department?
It was fully established. You know, the interesting thing is the air and liver temperature times are given, date and time. The livor and rigor mortis statements do not have an exact date and time listing, but it's taken at or about the time the liver temperature is taken.
Which is what time?
Well, on the Cole Brown Simpson, liver temperature was taken at 10:50 hours on 6/13/94.
Would you agree that the closer you take, the closer that you make the observations of the 4 indications you've talked, well, the 3, let's not talk about stomach content. The closer you make the 3 observations to the time of death, the better chance you will have of accurately establishing parameters for time of death?
Yes.
And would you say that it's proper procedure if a decedent was found at approximately 10 minutes after midnight to wait 10.5 hours to perform these temperature evaluations?
Objection, Your Honor, they can ambiguous as to what is proper procedure.
Do you understand the question, Doctor?
Yes.
All right, then I'm going to go ahead and let you answer it.
The measurements are more accurate the closer to the actual time of death.
And are there people available from the coroner's office to make those measurements at the request of homicide detectives?
Yes.
Now, regarding the stomach contents, you say that was something important that you use as a criteria for establishing the estimated time of death of the decedent Nicole Brown. Is that correct?
Yes.
And I take it those stomach contents are materials that can be preserved for later analysis. Is that correct?
Can be, yes.
And in fact, on the forms that you use, there's a checkbox for toxicological specimens collected. Isn't that correct?
Yes.
Did you save the stomach contents?
No.
Were you able to determine who died first, the decedent Goldman or the decedent Brown?
No.
Do you have an opinion as to the time of death of Nicole Simpson?
I give you a range.
What is that range?
Somewhere between 9 o'clock and midnight.
Now, is there something in the report that indicates that one of your investigators had information from the mother of the decedent that she was alive at 11 p.m.?
Your Honor, I'm going to object now because counsel is attempting to elicit inadmissible and unreliable hearsay evidence.
I think it would be admissible only if the doctor relied upon it in formulating his opinion. And it would not be offered then for the truth of the matter, but for the fact that the doctor may have relied upon it. And I don't know whether he did or did not, and therefore until that foundation is established as to whether he relied upon that in forming his opinion, then the objection would be sustained.
Yes. And I understand the court's ruling that should it be permitted, it would be only for the limited purpose articulated by the court.
Correct.
Do you have any information from any investigator that's filed under a County of Los Angeles investigator's report for the Department of the Coroner regarding the last time somebody saw or spoke to Nicole Brown?
Yes?
What information did you have?
Am I allowed to testify on that?
Your Honor, may I'm going to object for lack of foundation because there's no indication yet that this witness relied upon that information, whatever it may be.
Yes, Mr. Shapiro, I think that you need to establish that foundationally before I would allow that testimony to come in.
Thank you. You previously testified that you read all these reports, is that correct?
Yes.
Did you read
Not in exact detail. I did look at them. In fact, some of these reports were preliminary. May not have been fully prepared at the time I did the autopsy.
When was the report that's we're referring to that has in the upper left-hand corner number 3 prepared?
The form number 3 prepared by investigator Radcliffe was prepared at 6/13/94.
Was that before or after your autopsy?
6/13/94 should have been prepared before the autopsy.
Have you had enough time to prepare yourself to testify in this case today?
Yes?
You had enough time to review your reports?
Yes?
Do you think you would need some more time to prepare yourself adequately for testimony.
Your Honor, I object. That's argumentative.
Sustained.
Is it your testimony that you did or did not consider the investigator's report before you have testified here today in any area?
I did consider those parts of the investigator's report that I considered relevant to my testimony, and I've already testified about her her measurements that she took. That's the ones I've been asked about.
Is time of death relevant to your testimony?
Yes?
Didn't you just say that eyewitnesses are very important in establishing time of death?
Yes?
Would you consider a mother talking to her daughter as being an eyewitness to when somebody was last alive?
Well, I meant somebody actually witnessing the death. As often happens when death is pronounced in a hospital, we know the exact time of death.
What if somebody recorded the time of a telephone call? Would that be of any help to you?
Objection, Your Honor. That calls for speculation.
Overruled. Can you answer that? Are you able to answer them?
A telephone call to the decedent?
That is what you mean, isn't it,
Yes.
Mr. Shapiro? Yes.
Yes, that would be useful.
Is there anything that was done by anybody from the coroner's office to try to ascertain that?
Objection, that calls for speculation.
Has the official reports you can look at?
Overruled. You can answer.
Yes?
What is it?
And, Your Honor, now I will object on the grounds that counsel is attempting to elicit hearsay. And hearsay of a potentially unreliable nature. There is an addendum to the report to which counsel is referring, which states, in part, this following information summary is based on preliminary information and cannot be completely verified at the time of this report. In addition, what counsel is attempting to elicit does not fall with an exception to the hearsay rule, even though contained in what may be characterized as an official record, you still have second-level hearsay. So on all those grounds, I object.
I still don't think, Mr. Shapiro, that you've established the foundation that the court felt needed to be established before that information could come in for the limited purpose for which the doctor considered it. If he indeed considered it. I don't know whether he did. That's the foundation that has not been established.
Well, I believe, Your Honor, he has testified that an eyewitness to, or somebody establishing the time the decedent was last known alive would be one of 6 factors he would consider in establishing time of death.
I understand that, but specifically in this case, there's been no testimony that he in fact did rely upon any statement from someone indicating that they had had a telephone conversation with the decedent. And that's what you need to establish before I'll allow that testimony, and for a limited purpose only, not for the truth of the matter.
If you had some information as to the time the decedent was last talking to her mother, would that be of any benefit to you in coming to your estimate as to the time of death?
My estimates are based on the body measurements. I did not use any information about a telephone conversation.
Did you see any information about a telephone conversation when you came to your conclusions?
I heard about a telephone conversation and did see it in the report.
Who'd you hear about it from?
The initial report of the telephone conversation?
Yes.
believe I heard it on the news or in the paper.
Is that before you saw it in your report?
Yes.
You mean the news had it on before it was in your investigator's report on the 13th?
No, I believe the news used the investigator's report, preliminary investigator's report.
Are you saying the news read the report before you did?
Oh, no, I'm not saying that at all.
My question now is...
All I'm saying is I did not use any telephone conversation to come to this time of death determination. I'm using body measurements and rigor mortis, livor mortis, cooling of the body, and gastric contents. That has nothing to do with a telephone conversation.
That's 10.5 hours after the fact. And you would rather rely upon that than upon a mother's testimony that she talked, or a mother's comment that she had a telephone conversation with her daughter? Which one do you think is more accurate?
Your Honor, that's compound.
Among other things, sustained.
Okay, we'll go on to something. We'll go on to something else. Do you have an opinion? You observed the stomach contents of the decedent, Mr. Goldman, is that correct?
Yes.
Did you save those?
Yes.
Why'd you save his and not save hers?
Well, first of all, I did not think it was indicated to save the contents on the Cole Brown Simpson. It was important to measure it, characterize it, describe it, and I did not think it was indicated to save it for toxicological examination. Of course, saving blood and other body fluids was very important for toxicological examination, which is what we did. The duty to characterize the gastric contents and measure it and describe what was in it was important, which is what I did. On Mr. Goldman, again, blood and other body fluids were preserved. On him, I was asked to save the gastric contents.
Who asked you to do that?
My chief supervisor, Dr. Lakshmanan.
Do you have an opinion as to, between Nicole Brown and Ronald Goldman, who was the last one to consume food?
I have no opinion on that, no.
Did you form any conclusion or opinion as to whose food was more digested in the stomach?
Mr. Goldman's food was more digested than Nicole Brown Simpson's.
If he ate after she did, would that mean that he lived longer than she did?
If he had a meal after she had a meal,
Yes.
does this indicate that he lived longer than she did?
Yes.
Well, I don't know for sure. His state of the food being more digested in his stomach could indicate that he had the meal earlier, or that he had a lighter meal, and that digestion started sooner, whereas her food being in a less digested state, particularly what I observed, a lot of the food appeared to be unchewed, particularly some of the particles of rigatoni were unchewed, and that could indicate that the unchewed food could remain in the stomach for a longer period of time before digestion.
Regarding the knife wounds, is it your findings that there were 2 types of knife wounds on both victims?
There are 2 morphologically different types of stab wounds on the victims. Namely, some of the stab wounds on the victims are indicative of a single-edged blade for the reasons that I indicated. They have both a round or blunt end and a pointed end. And some of the wounds have a characteristically double pointed or forked end, which would indicate that they could be made by either a blunt end instrument or knife or a double sharp end instrument. In other words, a 2-edged knife or a single-edged knife. And there's no way that my determinations can tell the difference between those. So there are 2 morphologically different types.
Could 2 knives have produced the injuries on both of the victims?
Yes.
Was there any evidence of any sexual attack on the decedent, Nicole Brown?
No, there wasn't.
Did you look for any semen, saliva, hairs, bloods that might be left behind on the victim of a sexual attack?
Okay, that would be performed by a criminalist to collect and preserve that evidence, and I wouldn't do it, and it's my understanding that it was not requested or performed.
Was there any attempt made to look for semen in Nicole or Mr. Goldman at the scene or at the autopsy?
Not to my knowledge.
Is it proper, in your opinion, to do a rape kit analysis on young women murder victims as a general rule?
The circumstances would dictate whether that procedure would be performed, and the investigators are the ones who would initiate that request.
Detective Van Adder brought you a knife to examine.
Yes, he did.
When was that?
Wednesday, so that would be Wednesday, June 15th.
Was he alone when he brought that to you?
Yes.
Where were you when you received that knife?
I was in my office at the coroner's office.
Did he give you a chance to examine the knife?
Briefly.
Did you ask him, did you tell him you might have needed, did you need more time than he gave you to examine it?
For an accurate scientific examination, yes.
Did you tell him that?
No.
Why not?
I didn't think it was indicated.
Wait, a detective who's in charge of a homicide comes in with a knife, and he tells you this may be similar to the murder weapon. Is that correct?
Yes.
He asks you to check to see, and you're telling us that you didn't think it was indicated for you to perform a proper evaluation?
Well, I said it could be the weapon that caused some of the wounds, including the cutting wounds. It was a single edge. It had a single sharp cutting edge, and it's obviously consistent with many of the slashing wounds. And it was a 6-inch blade. And at the time, we didn't think it indicated, or I didn't think it indicated to go through each wound wound by wound, just to try to exclude that weapon, that can be done at some other time.
You understand a man is sitting in jail faced with charges of double homicide, do you not?
Yes?
Well, when could that be done to protect his rights?
Objection on our argument.
Sustained.
When would you suggest doing that to protect his
That
rights?
same objection.
Sustained is the form of the question.
When would you suggest doing these tests?
Now?
I have nothing further.
Mr. Hodgman?
If I may, just a moment. Yeah, thank you, Your Honor. Dr. Golden, with regard to your testimony today regarding time of death, these are estimations, are they not?
Yes?
These are approximations, are they not?
Yes?
And there is not a way, even based upon the criteria articulated in court this afternoon, for you to pinpoint a time of death. Is that correct?
Yes?
The best you can do is give us a range of time in which time of death might have occurred. Is that correct?
Yes?
And that is an approximation at best, is it not?
Yes?
That's all I have, Your Honor.
Mr. Shapiro, anything further?
This witness may be excused.
Thank you, Doctor. You may step down. Please do not discuss your testimony with anyone but the attorneys involved.
At this time, Your Honor, people would ask that all of the exhibits marked, with exception of people, we originally marked people's 4 and 5, be admitted into evidence.
All right, that would be exhibits number 1 through 33, with the exception of people's 4 and 5. Mr. Shapiro, do you have any objection to the receipt of those exhibits?
No objection.
Thank you, Mr. Ullman. People's 1 through 33, with the exception of 4 and 5, are received in evidence at this time.
Thank you, Your Honor, the people rest.
Will there be any affirmative defense or other evidence offered by the defense?
Your Honor, we did proffer a stipulation and shouldn't be that much people are willing to accept that stipulation.
There's no evidence to support the stipulation proffered. There will be no stipulation.
All right, did you wish to offer any of your exhibits that had been offered in connection with the motion to suppress?
Yes, we do, Your Honor. All of them.
All right. That would be defense A, B, C, D. The court did not allow E, G, or H. So are you seeking to offer only A, B, C, D, and F at this time?
Yes, sure.
Any objection?
No objection.
Those items are received from the defense. Do you have any motions at this time?
Before we begin considering an affirmative defense, there would be a motion to dismiss the case.
I'm sorry, you say before you begin considering
Yes,
affirmative
I think at this
defense?
point in time, we would like to make a motion to have the case dismissed.
That motion is denied. Did you wish to present an affirmative defense? Yes.
Suggest a 5-minute recess so I can confer with counsel.
All right.
Is once again in session.
All right, we're once again on the record in the case of People versus Simpson. The defendant is present with counsel. People are represented. Mr. Shapiro.
Yes, Your Honor. I have decided not to present any affirmative evidence at this time. And
All right. Do you have any other motions that you wish to make at this time, or be heard with regard to any motions?
Yes, Your Honor, I would like to be heard on the motion to dismiss.
I'll hear you at this time.
Thank you. Would you like me to go to the podium or stand here?
I think the podium is probably better.
Your Honor, I would ask the court to consider the jury instruction that would be given in a case like this regarding circumstantial evidence. And that is, if the evidence presented relies solely on circumstantial evidence, there can be no conviction unless the circumstances point to guilt and are not reconcilable with any other reasonable theory. If, on the other hand, the circumstances may point to guilt or may point to innocence, the jury or finder of fact must adopt that theory which points to innocence and reject that which points to guilt. Now, clearly, this is not a trial, and clearly the burden is not the same. But the legal principle remains. This is a case based entirely on circumstantial evidence. And it is clear from the presentation of the people and through our cross-examination that the circumstances can point both towards a suspicion of guilt and also towards a theory of innocence. The key piece of evidence that the people are relying on is the serology of a 99% chance that 4 blood drops found at the Bundy crime scene were of the same type and chemical composition of that of Mr. O.J. Simpson.
Objection, that's a misstatement of the evidence.
This is argument, Ms. Clark. You can be heard in response at the appropriate time.
The converse of that is that if you take the Coliseum on any given Sunday, 40,000 to 80,000 people will have that same blood type. Number 2, there was testimony elicited from the people's witness that Mr. Simpson has joint custody of these children with his ex-wife, the decedent, Nicole. That being the case, it is reasonable to assume that he would visit the children or pick them up at her condominium on a regular basis. Since the criminalist cannot fix the age of the blood spots, there is an equally reasonable theory that those blood spots, if in fact they belong to Mr. Simpson, were placed there at some other time than at the time of death. And in fact, the criminalist testified that by viewing the photographs, the blood appeared to be of different ages. However, he blamed that on poor photography. But on cross-examination, he admitted that proper crime scene photography requires using the same type of equipment with the same lighting conditions from the same angle. Point number 2 that the prosecution relies on. There is a matching glove found in the debris behind the Simpson residence that matches a glove found at the crime scene. Let's go by the testimony. I asked Deputy Van Adder, how did that glove get there? He said, someone brought it there. Let's look at the other circumstantial evidence involved. If, in fact, the killer lived at the Simpson residence, the court would have to believe the following: that in a window period of less than an hour, the killer was able to leave the crime scene that has been described with a victim with 2 arteries in the neck cut, 2 jugular veins cut, and massive blood from both victims. A clear inference would be that the murderer was indeed covered with blood. The murderer would then have to do the following: abandon the bloody clothing because they have not been found or presented, abandon the murder weapon because that has not been found or discovered, abandon bloody shoes because they have not been found or discovered, and then go back to his house and leave a bloody glove in his backyard. That just doesn't stand up to logic. We have no evidence whatsoever in this record that whoever committed this horrendous act acted with premeditation and deliberation, as is charged in the complaint filed by the district attorney. This is a case that the police admit is still under investigation, where other suspects are being sought, where the medical examiner admits that 2 weapons could have been used. A clear inference that there may be more than one killer. I don't want to go through each and every area of impeachment with the witnesses, but I think it is very, very clear that everybody who has participated in this investigation has not done so in a professional manner. From the time the Los Angeles Police Department arrived on the crime scene, it was nearly 10 hours later until they started the scientific investigation and even took the temperature of the body. There was testimony that the fire department obviously was there and left and didn't do anything, yet the coroner's records clearly indicate that the fire department chief was the person who pronounced the bodies dead. I doubt if he did that from a distance. This is a case that everybody has jumped to an immediate and unrealistic conclusion